Hello, my name is Alyssa Craven. I'm the Grand Families Director at Children's Service Society. Grand Families is a nonprofit program and is designed to support kinship caregivers who are raising a relative's child. We have family advocates that assist with case management services, resource referrals, guardianship applications, financial assistance applications, as well as whatever other needs the family has. We also offer psychoeducational classes and we hold monthly events to help connect the caregivers. If you are interested in learning more about our program, you can reach us through the website or at our phone number 801-326-4409. I am here today to walk you through the process of applying for guardianship of a minor. While our family advocates are able to assist with this process in office for free, we do also want to provide the information so that if you feel comfortable applying for yourselves, then you can follow this process and you should be able to do it on your own. But again, if you have any questions throughout the process, please feel free to reach out to one of our family advocates. To start out, I wanted to explain a little bit about guardianship in Utah and what this means. So in Utah, caregivers can file for a guardianship of a minor, which a minor is anybody 18 years or younger. And it's done through the district court in the county in which the child resides. The paperwork that you access to file for a guardianship is found on the website www.utcourts.gov/OCAP. That stands for Online Court Assistance Program. So you'll access the documents online, fill it all out on there, print it, and then file it with the court. It does not submit automatically online, so it'll have to be submitted to the court either by email or in person. What a guardianship does is it suspends the rights of the parents and transfers those to whoever the requested guardian is or co-guardians. It does not terminate the parental rights, and this is important to know because those parental rights, while suspended, are still there if the guardianship is terminated by a judge through the court. So while you have the guardianship, this grants you the rights and responsibilities over the children. You can seek medical care, you can get them into school, you can make decisions for them. And then it's stable enough that the parents cannot come and take the children from the home, or others cannot come and take the children from the home unless you consent to that scenario. So it is stable. It's considered a temporary guardianship in that it can be reversed. However, it stands until either you file to terminate it or another party files to terminate it and a judge grants that order, or until the child turns 18, and then you would file the motion to terminate that once the child is considered an adult. A little information about what to know before you file the paperwork. First thing, very important, the child or children must be living in the home of the requested guardian by the date of the hearing. So you can file the paperwork without the children being in your care. However, at the time of that hearing, when you go before the judge will want to know if the children are living in your care. If not, judges generally cannot grant a guardianship for the removal of the children from someone else's care, especially without parental consent. So just be aware of that the children do need to be living in your care on the date of the hearing. Every reasonable effort must be made to notify the biological parents of the children and obtain consent from them. If location is unknown or if they're not willing to consent, there are other steps that you can take that I'll walk through later in the process. However, the judges generally want to know that those efforts have been made to notify the parents. And then the last thing to know is that children ages 14 and older are required to sign an acknowledgement and or attend the court hearing. The judges want to know how the youth feel about this order. Do they consent to it? The judge may still grant it even if the child doesn't support it, if they find that it's in the best interest of the child. However, they do want to hear their perspective on the situation. So it is a requirement that they do sign that acknowledgement. And sometimes the judges will require that they are present at the hearing. Other times they do not require them to be present at the hearing. So it'll just depend on the county and the judge that has been assigned to the case. With that said, I am going to transition over to the court website. So as I mentioned before, it is utcourts.gov/OCAP. It'll take you to this website right here. And you will scroll down until you see this box that prompts you to log in or create an OCAP account. You will need to have an OCAP account in order to proceed with these documents. So if you have not created one yet, you will want to create that, and then you'll want to record the information somewhere safe where you can then remember your password and everything to then go and log in again for if you need to change anything on the documents or file an annual report or anything else on the website. So if you're new to this site, you will use this right side here, and you will enter in your information and create a password and your account, and then you'll save it. I have already created my account, and so I am going to log in. When you're in, you'll see this page. If you have already created documents in the past, you will see a list of them right here, as long as they haven't been inactive for 180 days or more. So those will show up on this side. To start a new petition, you will go to the list over here and search for the guardianship. So you will click on the guardianship of a minor documents, and this will open up a new, what they refer to as an interview, and this is your paperwork that you will file. You may enter your username and your email address associated with the account if you would like them to follow up with you through that. This one is not a required page. However, if you would like to, you can put that information there. And then here's some information telling you about the guardian and conservator exam. So for the first caregiver or the first guardian, there is a guardian and conservator exam that will come up on the next page that in order to continue with the paperwork, you'll have to complete the exam. If you have co-guardians that you're listing on the documentation, then they will need to complete a separate guardian and conservator exam, which can be found on that main page right above these documents. So it's the same questions, but the co-guardians will need to complete that to ensure that the judge knows that you understand rights and responsibilities as a guardian. I will continue forward and show you what that exam looks like. So anytime you want to continue, you'll go down here and click Save and Continue. This is the guardian and conservator exam that everybody will take. What you'll do is you'll read through the question, answer yes or no, and it'll tell you right away if you've answered it correctly and give you a response as to why that's accurate or inaccurate. So the nice thing is you can get through it. Even if you're not sure, you can answer one of them and then it'll educate you on what the answer is. So number one, a guardian is responsible for care of a ward. Anytime you see the word ward, that is referring to the minor child that you are seeking guardianship of. So a guardian is responsible for care of a minor child. Yes. And it tells you you're right. And then it gives you the reason as well as the code that you can reference for that. A conservator is responsible for the property and financial affairs of a minor child. Yes. So now this one, this guardianship paperwork is technically for a guardian and conservatorship. However, with minor children, most likely the children in your care are not going to have many assets that they're coming with. And so there won't really be property or financial affairs that you'll need to take care of for the children, in which case anything related to the conservatorship side, you don't really need to worry about. If they do have assets and things like that, then this part you will want to worry about. The appointment order contains a statement of your powers, rights, and duties. Yes. This one defaults to I am a guardian because you're in the guardianship paperwork. As guardian, you are required to make reports to the court only when there is a significant change in your child's condition. No. So this one, you need to make a court report anytime anything changes. So address or whatever the significant change is, you will need to report that within 60 days of when that happens. When making decisions about your child's care, you should do as you think best. This one is no, because it adds that you need to be thinking, what would the child do? Or if they're too young to make some of those decisions, what is in their best interest? And that should be respected. If you can no longer carry out the responsibilities of a guardian, you should ask someone else to take over for you. That is also no. So that has to be done through the court. You cannot do an informal placement outside of your care if that order is in place. Therefore, if somebody else has stepped up and is going to take on the care of that child, then you would need to file a motion to terminate your guardianship and then file for the new caregiver. You must file a complete inventory of the property owned by the ward within 180 days of your appointment. The important part to note right here is the 180 days. This one is false, and that's because it has to be filed within 90 days of your appointment, so within that first 3 months. Every year within 60 days after the anniversary of your appointment, you must file an accounting with the court. Yes. Sometimes the courts will notify you of the anniversary and that those documents are due. Sometimes they will not. So it's very important to take note of the date that the guardianship is granted and make a note in your calendar to follow up on that, because within the 60 days after that appointment anniversary, you will need to make that report to the court. The reports that you have to make must be made on court forms. This is true. Those forms can be found on the same website, and everything you'll need for the annual reporting is there. After you prepare an annual report, your only responsibility is to file it with the court. This is false. It will need to be sent to anybody who has an interest in the child's care. So the child themselves, if they're old enough to understand, if they have a spouse, if they have any adult children, they have to be notified. The parents of the children have to be notified of that annual report as well, and any brothers or sisters if they are old enough. So this is the reference to that guideline if you have any questions or concerns about who to notify of the report. The court may impose a penalty for failure to file a required report. Yes. And that's why it's so important to make a note of the dates of when those are due in case you don't receive notice beforehand, because they can charge you for that. When you are uncertain about your responsibilities, the best course is to consult a lawyer. That is yes. So if there's any questions or concerns, because this is a legal case, you will want to seek legal support, which can be done through the Self-Help Center or by finding an attorney as well. You should record financial transactions made on behalf of your ward on a monthly basis. The part to note here is the monthly basis. This one is inaccurate because they want you to make a note of it as they happen. You should open a separate bank account in your name to manage the child's money. Nope. It needs to be done in the name of the guardianship. So in the name of the child, that's where it needs to remain. Your primary responsibility with regard to your child's property is to increase its value. That is incorrect. It is to preserve what is there and to use what is necessary to support the child. And the last one, you are automatically entitled to receive reimbursement for room and board that you furnish to the child. That is incorrect. So if you are seeking for reimbursement of any of these things, you would need court approval generally for a guardianship of a minor. I haven't seen that done. Okay, once you have passed the guardian and conservator exam, you will save and continue, and it'll save your responses. It gives some additional information about filing. It tells you that there are 3 ways to file. You can either save the PDF at the end and email it to the court. You can print the documents and then mail them to the court through the postal service, or you can print them and hand deliver them. We always recommend that caregivers hand deliver them. That way you can check with the court clerk to make sure that there's no issues with it. Then we'll save and continue. Now it'll ask you if you are seeking guardianship of a child, of someone who is over 18 years of age, married, in the military, or emancipated. If you say yes, you'll see over here, you're not eligible. Because this is a guardianship of a minor, they do need to be under 18 and unmarried and all of that. So you will want to say no, and that'll bring up the rest of the documents that you'll need. So you'll save and continue. Okay, and then we get into filling in your information. So I will walk through everything that is in red is required to save and continue. So if you miss anything that's red, it will not let you continue until you have filled that information in. So it's important that as you're filling this out, that you have all of birth dates and contacts and things like that ahead of time so that you can put that information in. So the petitioner is generally going to be you. Whoever's filling out the paperwork is going to be considered the petitioner. So I am going to fill this out. So you'll do first name and last name. Make sure everything is spelled accurately as well. Because it is a court document and legally binding document, you'll want to ensure that you have the correct spelling on everything. And then you will select your gender, phone number, and your address where you reside. And city, we'll say Salt Lake City. Select your state. If you select another state outside of Utah, it does not let you apply. You have to be a resident of Utah to be able to apply for a guardianship in Utah. You can put your email, but it's not required. You'll select the county because then that will refer you to the proper court. And then it asks, is this petitioner asking to be appointed as a guardian? So are you applying for somebody else? You're the petitioner, but somebody else is going to be the guardian, then you'll say no. In most cases, it is the caregiver that is applying and requesting to be appointed as a guardian, so you would say yes. And you will save and continue. Then it asks where the child resides or is present. So this is where it is going to refer you to the county court of where the child resides. So we're going to say Salt Lake County. It gives you the address of where you will file the paperwork. So it will go through the 3rd District Court on South State Street. Then you are going to fill in the child's information. And their date of birth. You'll select their address. So if they live with you, then you'll already have that in there and be able to pull that up. If you need to enter a different address, then you can do that on there. The other nice thing is on date of birth, it tells you how old the child is. So if that says 14 or older, there will be another form for them. Will the petitioner be a guardian for this child? Yes. What is the relationship? We're going to say grandmother. Will another person be guardian over this child? So we're going to add a co-guardian. So I'm going to say yes, and you're going to enter in that name. So we'll say grandparent. And this is first and last name on this one. What is the relation? We're going to say it's grandfather. Does this guardian live in the United States or its territories? And we're going to say yes. And we're going to use that same address as above. You can have two separate addresses for two different guardians. So let's say you're a grandparent and you have an aunt or an uncle that is also involved in the care of the child, but does not reside with you and resides somewhere else. And maybe the child floats between both homes. That is completely okay. You can list both addresses, and it's okay to have them in two different locations. The child's primary residence is the one that you'll want to list though, and file under. Then you will list the second guardian's phone number on here. Will another person be a guardian over the child? So it lets you add up to 4 co-guardians on here. I'm going to say no, but the process is the same. If I said yes, same thing, all of this information you'll fill out. If no, then it has you move on. Then it asks you if the child is of school age, and I'm going to say yes because they're 8 years old. And then it requests that you list the name of the school district. So I'm going to say Granite School District. You'll list the street address. So you will just look that up for the, I don't know it off the top of my head, so I'm just going to make up a number. The city, we're going to say it's in Salt Lake City. I don't know the zip code, so I'm going to default to where I'm at. So what happens is an affidavit, because you've selected that the child is school age, an affidavit will come up that requires that the school district office will need to sign acknowledging that the child is enrolled in school within that county. So it's their understanding that you are seeking guardianship of this child, and they know what's happening. Then it asks you information about the child's possessions. So what assets or things like that do they have that would be entering your home? Most of the time, these are all going to be zeros. So if they don't own any land, buildings, furnishings, vehicles, you're going to put all zeros on these things. If you have any questions about what is counted and what is not, again, you can reach out to one of our family advocates and we'll help kind of talk through that. Then it talks about interested parties. So this is where you will fill in the information for the parents. It also lets you know who all is considered an interested party. So any living parent, the child, if they're 14 years or older, the school district, if the child is 12 or older, and then any other interested parties. That it does have an option to list any interested parties outside of that. So in this case, we're going to say mother, grandfamily. Is the mother alive? If you say deceased, it asks you to submit documentation showing that. If they are living, it asks if the mother lives in the United States. So you'll say yes or no. If you say no, it just has more information on foreign states and country. If you say yes, less information. Let's say you do not know the address. Mother's whereabouts are unknown. You can type in unknown and just put an approximate. I think she might be in Ogden, but I'm not sure. It's okay if you don't know, but you will need to list these to continue. So you can select a city, you can default to your own city or the last known address if you know it, but try your absolute best to have this information. If not, it's okay. Let's say you do know, you're pretty confident they do live in Utah though. Phone number, generally, to my understanding, the court is not contacting them with this information. They just want to know, do you have information for them to be able to contact them? So if you don't have a number, you can put all zeros. If you do have a number, then you'll want to put that there. Okay, and then it gives you information about what to do in certain situations regarding the mother. And then it has some questions that'll ask you specifically about the mother. Would you like the document for the mother to consent to guardianship? So generally you'll want to say yes, because as I mentioned before, you'll need to make every reasonable effort to get that consent from the mother and from the father as well. If whereabouts are unknown, you know you're not going to be able to get that consent, then you can say no, but you will want to say yes on submitting an affidavit. So if this is no, this one has to be yes. If this is yes, this one can be no. So we're going to say yes, you want the consent form. Are you submitting a prior court order showing the termination of their custody, of the mother's custody rights? If you have a prior court order showing that, then you'll select yes. If you don't, then you'll select no. Are you submitting affidavits explaining why the mother is unable or unwilling to exercise custody rights and responsibilities? This is a written statement under oath that you'll sign in front of a notary stating the reasons why the mother is not able to sign consent for, but also unable to take care of the children at this time. So if you have selected no to the consent, you will need to select yes. You will be submitting an affidavit explaining why the consent is not there. If you would like to include an affidavit in general, like yes, you're doing the consent form, but she's not going to sign it, then you'll select yes to that. If you know mom is going to consent, this one's not necessary, so you can say no. Are you submitting other relevant documents showing the suspension of mother's parental rights? So are there any other documents that show that that's been suspended in any other means? If not, then you'll say no. If you do, you'll say yes. And then it asks military status. So is the mother, like, is she in the military? Do you need to give the court proof of that military status? So if not, say no. If you say yes, then it gives information on what that status is. Then it's going to go through all of the same things for the father. So is the child's father alive? Yes or no. We're going to say that he is living, that he does live in the United States. Address, let's say we have an address for him. And he's in the area. Another thing you can do on here, let's say the father is incarcerated. You can put the address of where he's incarcerated. So if it's here in Salt Lake and you have the address, you can put that there. And a phone number, again, if you don't have it, you can list all zeros. If you do have it, then you'll list it. Same questions, a little bit different order on these ones, so you'll want to be aware and make sure that you're reading through each one. Would you like the document for the father to consent? I'm going to say yes. Are you submitting affidavits explaining why they're unable or unwilling? If we've said yes up here, you won't need to submit any affidavits. Are you submitting a prior court order showing the termination of the father's custody rights? We're going to say no. And are you submitting other relevant documents showing suspension? We're going to say no. Then it asks military status again. We're going to say no, not in military. Okay, that completes all of the information for the first child. I'm going to look up and make sure that nothing is red. I don't think I've missed anything, so I should be good to save and continue. The important thing to note, if that's the only child, you'll save and continue. If you have a second child, then you will do this button right here that says click here to enter the information for another child. So I'm going to do that one just so we can see another option. So we're going to do sibling. We're going to put their date of birth. We're going to go a little bit older so we get that 14 years old. So I'm going to say, let's see if that puts on there. And they do live in, oh, we're going to go a little bit later. Okay. My numbers are getting a little weird. Okay, 2009. And we're going to see if that continues. So will the caregiver be a guardian for this sibling? Yes. It did change the age up here, 14 years old. So they will have a consent form. And then it asks, has the child, so I think if you automatically default, or if you go to 14, then it asks this question here, that has the sibling lived outside of Utah during the previous 2 years? If you say yes, then I think it brings up additional information for school districts. If you say no, then it lets you continue. Will the caregiver be a guardian for this sibling? Yes. What is the caregiver's relationship? We're going to say grandmother again. Will another person be a guardian over the sibling? Yes. We're going to fill in the same information, grandfather. And the relationship is grandfather. Does this guardian live in the United States? Yes. We're going to do that same address from above. And whatever their phone number is, I can't remember what we did. I think we did backwards. Will another person be a guardian over the sibling? So a third or a fourth? We're going to say no. Is this sibling school age? Yes, they are. They're in Granite School District as well. Okay, and then it's going to ask for the assets of, or the estate value for sibling. So I'm going to mark all zeros for this sibling as well because they don't have any assets or income. And then notifying the parents. So we're going to do same thing. The mother is living and in the United States, but from before we don't know the address. We're just going to guess that it's Salt Lake, but we don't have an actual address for her. And we didn't know her phone number, so we're listing all zeros. Let's say, we're going to go through these questions first. So would you like the document for mother consent? We're going to say yes, because we also requested it on the previous sibling. Are you submitting a prior court order showing termination? her rights have not been terminated yet, so we're going to say no. Are you submitting affidavits explaining why the mother is unwilling or unable? Because she's going to consent, we're going to say no. And are you submitting other relevant documents showing suspension? We're going to say no, because her rights have not been previously suspended. Military status, we're going to say no again, that we don't need proof because she's not in the military. Let's say that sibling has a different father. So we're going to say dad this time. And this father, we're going to say is deceased. So that one will require a additional documentation of a death certificate. If you have a third sibling to add, then you will click here to enter that information, but we're going to say it's just the 2 children, and we're going to save and continue. And then it asks you, do the children you want consent forms for have the same father? We're going to say no, because it was 2 different fathers. You have father, grandfamily, dad, grandfamily. And this father, we don't need a consent because he's deceased and other documentation will be submitted. And then it asks if the children have the same mother. So we're going to say, yes, they have the same mother. And then you'll save and continue. And then it asks you if there are any other legal actions pending for guardianship of the minor. Are there any other caregivers, maybe another set of grandparents who are also applying for a guardianship? In which case you will want to select, yes, there are, and you will describe what those legal actions are. If there's no one else taking any legal actions, then you'll say no and save and continue. Are there any caregivers who should be notified of this guardianship proceeding? Anybody that's listed as co-guardians on this documentation will already be notified. But if there's anybody else who's interested in the case who you want to be notified of this, then you'll say yes. And it'll bring up another section where you'll fill in that information. Most of the time, families are marking no, they don't need to notify anybody else. Has anyone been appointed guardian who did not accept the appointment? So we're going to say no, there's never been any previous proceedings and we don't need to worry about that. Is there another interested party who should be notified of this guardianship proceeding? So any other, if you have community partners that are collaborating with you on the case, helping you through things and you want them to be up to date on that, then you can select that you want them to be notified as well. Otherwise, you can say no, and you can notify anybody you want that you think is interested. But this option, by selecting no, it just means the court is not going to notify additional parties. If you want the court to send notification to others, then you would say yes, and it brings up that other tab of other party information. So we're going to save and continue. Then it asks you the type of guardianship you're applying for. Are you applying for a full guardianship, which gives you all rights and responsibilities under the law? Or are you applying for a limited guardianship and describing what that limited would be? So let's say you're wanting a guardianship that is just for school purposes. You can describe that here. So caregivers seeking guardianship for school purposes only. Medical care will still be responsibility of parents. You can specify what you want that for. Most of the time, caregivers are seeking a full guardianship, and so you don't need to worry about that section. Then we'll save and continue. It asks if you believe that bonding is necessary for the person nominated as guardian. So bonding is money paid into the court. Generally with a guardianship of a minor, this one is a no. I've never seen bonding being necessary for these situations. Then you'll save and continue. Then it lets you know what the court filing fees are. So there's a total of $395 that you will pay at the time that you file. If you feel that you are unable to pay these fees, you can submit a fee waiver. So if you say no, then it brings up information about financial things so that you can apply for that to be waived. If you do feel that you're able to pay this, then you'll say yes and you'll continue on. So I'm going to say no, just so you can see what this portion looks like. And then it asks you if you qualify for a waiver. So do you receive food stamps, supplemental security income, Medicaid? Do you receive cash assistance from the FEP, the Family Employment Programs? Do you receive cash assistance from TANF, so like Specified Relative Grant, temporary assistance for needy families? You receive legal services from a nonprofit provider, from pro bono attorney? What is your gross monthly income, or is it below 150% of the federal poverty guidelines? And if you say none of these apply to me, then and you still want to ask, so let's say you want them still waived, then it brings up additional information that you need to fill out regarding your assets. So let's say you receive food stamps. I'm going to take that one off. And it looks like they're going to send you to reduced fees. But if you select any of these, it's not going to bring up that additional information that you have to fill out. But if you select the none, that's where you would need to fill out the additional information on that. So just be aware of that, if you feel you're not able to pay those fees, none of these apply, you will need to account for any financials. So in this case, I'm just going to say yes, that you are able to pay the fees, and save and continue. Again, it gives you reduced fee and free services that are available if you are needing resources that way. Then you'll save and continue. Then you're going to put where you will be signing the documents. So generally you're signing it, if you're filling these out online and printing them at home, you're going to sign them from your home, and then from Utah, and the date that you are going to be signing it. And then put in today's date. And save and continue. And then it tells you some additional information that you're going to view your documents. Everything is completed. If there's anything that is incorrect, if you notice any misspellings or an incorrect address or anything like that, then you'll want to go back and make those changes. You can select the tab that you want to go to specifically so that you can edit that information. If it's related to child number 1, you can go and edit that information. If it's sibling, you can go and edit there. Otherwise, you will save and continue, and it tells you it's the end of the interview, and you'll save and continue. And it brings up your documents. And this is a look of what you'll see. So you'll have your name as the petitioner. The court, you won't have a case number yet because you'll receive that when you go to and file at the court. So for your own information, you can keep a copy of this and write down your case number when they provide it to you. And then it is going to give you a list of all of the steps that you will need to take for this document. So you'll print your document, make sure it's only on one side. They will not accept it if it's double-sided. So it will need to be one-sided. And then you'll follow the steps on here. You'll read the packet, make sure that you understand everything within it. You'll sign the documents that need to be signed, and then you'll make a copy for your own records, and then you'll file the documents with your filing fee or with a fee waiver if you're submitting that. So you'll want to make sure you have each of these pieces of the document so you can check them off and make sure, yes, I have that and that before you file it. And then these are the methods. So if you're going to do it by email, you can click here and it'll bring up the email address. If you're going to print and mail it to the court, you can do that. I recommend hand delivery. That way you can get the court the case number from them, as well as some of the counties will give you a court date right then. They'll give you the date to come back, is what I mean by that. Then it'll tell you where you're filing it. So because we selected Salt Lake County, it's defaulted to their district court in Salt Lake County. And then that's the address that this document would be filed at. You can follow along on the case for free once it's been filed, so you can see on this link where your case is at. And you'll want to record down your case number and the judge's name once you've received that. You'll receive your court hearing, so you'll want to make note of that and notify any other additional parties that want to be present for that court hearing. And then there is a criminal background check on any child 12 or older, so the 14-year-old. The affidavit by the school district, they'll fill that out. So generally, I haven't seen a lot of the counties really require that criminal background check for the 14-year-olds for any of the minors, but you'll want to check with your county to make sure that that's not necessary. But for sure, the affidavit from the school district will need to be submitted for that. After you've attended the hearing and the guardianship has been granted, you'll receive your letters of guardianship, and you'll want to make sure that you get at least a couple of certified copies of that to have on hand for when you need them. Okay, then we're going to continue and I will walk you through what each portion of this looks like. Again, the declaration of completion of testing, so the petitioner has already completed that. We completed that at the beginning of the documentation. Co-guardian, so grandfather in this case, would need to go on and complete that guardian and conservator exam. It's the same questions. They just need to be able to show that they've taken it. And here's what your information looks like. So it will put your information in as the petitioner. You won't need to worry about anything else on this. And then it goes in and it has all of the information based off of what you have answered. It does show you the cost breakdown for filing. So the guardianship of a minor is $375 fee, and then there's a $20 online court assistance program fee that is to maintain the court website. Here's a private information record that will need to be provided. So you'll need the information filled out on here about the guardian, and then you can fill out your case number there once you have that. And then it's got the child listed who is at Granite School District, and your signature. It looks like it already comes with your signature on there defaulted. So you won't need to sign it. That's new. I will note sometimes they do change things around on these documents. So at the time that I'm making this video at the end of 2023, this is how it's appearing, but sometimes they do edit it. So there may be some things that look a little bit different as it prints out or as you're filling it in. So again, if you have any questions, please reach out to one of our family advocates. We generally have advocates working on these pretty regularly and are aware of any updates that happen as they do. And so if there's any concerns that it's not looking the way that I've showed you on here, please reach out and we'll help walk you through any changes that there may be. So it goes through the second child and their school information. And then here's the declaration of completion of testing. So you will sign acknowledging you did take and successfully pass that court-approved exam that was at the beginning of the documentation. So make sure that you sign this once you've printed it off. And here's the verified petition for appointment. So it lists the children who will be listed as their guardians, so caregiver and grandparent. I listed the wrong one there. We're going to pretend like that's the same one, but both grandfather. And again, that's where you'll want to check to make sure that everything is accurate, that you got the right addresses, the right name. Is it the same? Is it consistent throughout the document? I can go back and change that to make it consistent with the previous one. So if there's nicknames, you'll want to avoid those nicknames and use the full legal name. And then it provides every interested party on here. So the mother, both fathers, the information you've provided about them. So we didn't know the address for the mother, and we had the address for the first father, but the other father is deceased. So you'll want to provide the death certificate for that one. And then the school district information as well. And then it has on here sibling because they are 14 or older. So on this document, it states that the father acknowledges that he understands the legal effect of the guardianship and consents. Same thing with the mother for both children. Then it has the child, birth date. They'll be 8 years old at the time of the hearing. Sibling, their birth date, and they'll be 14 at the time of the hearing. Both children have 0 assets. And you'll sign acknowledging that everything above is accurate. These do not need to be signed in front of a notary. Unless it has a notary line, then you're good to sign it from where you're at. These are the estate value worksheets for the children. Everything we had listed as zeros, so it just shows that there are 0 assets for the children. This is the affidavit of suspension of parental custody rights. So you'll go through this and it explains what this means. So I, the caregiver, do solemnly swear and affirm to the best of my knowledge that the custody rights of the parents of the minors named above have been terminated or suspended by waiver of living parent circumstances or prior court order. To support this claim, I submit the following attached affidavits and or information to the court. And then we've got information here with consent forms. You'll sign. Here's the mother's consent form. So this is what you'll want to provide to the mother to sign consent for both children. So it's just one consent form, lists both of the children on here. So she's acknowledging that both grandmother and grandfather will be the guardians of the children and that her rights will be suspended. So she will sign there. If she's not willing to sign this, then you'll submit the affidavit. You can reach out to our staff for information on how to file an affidavit. This is the father's consent form. Same thing as the mother's consent. It lists the child whom he has, and they'll sign. You'll notice we didn't have the second consent form, and that's because we list that the father is deceased, and additional documentation will need to be submitted with that one. This is the affidavit of waiver by the school district. So this form will need to be taken to the school district office. You'll want to call ahead to your district office to make sure you don't need an appointment for that. Some of the offices allow you to walk in and they'll have somebody sign it right there. Others will need an appointment. So you'll want to call ahead just to make sure, and they will fill out this form. So generally it's the school district liaison, the homeless liaison that will fill out, or whoever the school representative is. So they will fill out based on their knowledge and sign in and date that. So you'll want to get that from them before you file it at the court. Some counties will send a representative to the court for the court hearing. An example is Davis County. Other counties don't require, or they don't send school district representatives. They just fill out the form and submit that. This is the nomination of guardian by the minor. So this is for sibling who is 14 years or older. They are going to sign acknowledging, because I am 14, the law allows me to nominate a suitable adult to be my guardian. I nominate the following persons, caregiver and grandfather, and respectfully request that the court enter an order appointing my nominees as my guardian. So they may nominate you as their guardian. And then the rest of it is what the judge will sign. So this is the findings of fact and all of the information that the judge needs to make the order and the conclusions of law. And the judge signs it on the day of the hearing if the guardianship is granted. And then here's the order of appointment that the judge will sign. And this is the acceptance of appointment. So after the judge has signed the order, you will sign your acceptance of appointment. Some of the courts have caregivers sign ahead of the court hearing. Some have you sign at the court hearing. So I would double check with the court clerk when you file. Do I need to sign this now? Is that what the judge prefers? Or do I sign it on the day of the hearing in front of the judge? There's one for both caregiver and the co-guardian. Co-guardian, it prints out two, one for each separate child. I'm not sure why it does that. And then here's your letter of guardianship. So once the judge has signed the order, you've signed your acceptance. This is the letter that you will receive showing that the guardianship has been granted. This is what you'll want to get several certified copies of so that you can have them on hand. It's important to have them anywhere that you may need it, that you'll want to file one with the school district. You'll want to have one in a safe place at home where you can access it. Sometimes it's helpful to have a copy of it in your car, in your purse, wherever you may need it, where there may be some legal issues where that may come into question, where you can prove that you have the guardianship in place. With doctors as well. It's really helpful to have. That completes the guardianship document. You will then save it so that you have a record of it and print it and file it with the court. And again, I will give our phone number if you have any questions for our family advocates, 801-326-4409. You can also email grandfamilies, GRANDFAMILIES @cssutah.org, and we will get in touch with you that way. Thank you.